All right. Good afternoon, everyone. This is Curt, and welcome to another edition of Fire Law Roundup for
whatever the heck today is, July 31st.
July 31st of 2021. And Brad, I didn't give you a chance to say hello. Go ahead.
Well, hello, everybody. And today we're going to start with a case which I'm going to almost immediately say I can't comment on. And the reason is it's a result of about $600,000 of misappropriated money in a fire company in Hannibal, New York. That's kind of upstate New York in the rural areas. This is a small rural volunteer fire company with a long, good tradition. And the headline, though, I'll let you turn over and I will be
you say the background on this one. You don't need to, Brad's got a conflict of interest with this one, and it's an important case, and it's not anything new. This is what we've been preaching for. I mean, I've been preaching it for the last 15 years since I really started focusing on the big picture national issue, but it involves the theft, the insider theft from volunteer fire companies. You can go back through some of, although Brad can't talk about the facts of this one, you can go back through some of our previous editions and you can see exactly how passionately Brad feels about this. I feel just as passionately that these types of things should not be happening. And to some extent, the responsibility falls upon the leadership of the fire department to put things in place to prevent these types of things from happening. But at any rate, we had a treasurer, and seems to have been a pretty interesting guy. He had been a member of that department for 60 years. There was some conflicting, and Brad, I don't want to put you on the spot here. There's some conflicting information whether or not he had been the treasurer for 40 or 50 years. So somewhere between 40 to 50 years, he had been the treasurer. And he was apparently voted out in March of 22, and that's when they started noticing some problems. He continued to hold on to the books, no surprise why, but he held on to the books at his house. All of the corporate financial records were at his house. By the way, I can tell you, I've had to deal with this as well, and it's not easy when you're dealing with a treasurer that is keeping stuff at their house, because there's a convenience factor there and nobody else wants to do it. And everybody trusts him. He's been around longer than most people, and I totally get that. But at any rate, when the department became aware that there was a credit card that they were not aware of, no one was aware of, and there was some questionable transactions, he was suspended. And apparently they called in the state comptroller, who will do audits of volunteer fire companies. And I think that's relatively unique. Many places here in Rhode Island, we don't have that kind of a capability. Maybe the Attorney General's office would come in, but primarily you're going to have to get your own.
But they did self-report. That's a big deal.
You're going to have to get your own financial folks in there and get in there and figure out what's going on, possibly the police and so on. But at any rate, in New York, the New York State Comptroller's office came in. And apparently the day that they were going to actually access this man's house to get those records, he committed suicide. So there were no criminal charges brought, and it looks like that part of the case is wrapped up. But at any rate, the state comptroller's report was issued last week, lists a number of recommendations, and those recommendations are so important. And by the way, there's not a one of them that Brad and I haven't talked about in the past.
Right. I will say this one thing about this, and obviously I don't want to say too much other than, look, we understand the community is upset, right? People should understand this because it's happening today. The community is outraged. And so when you don't look into your own finances, when you don't perform the internal audits and money is taken, the community gets upset at you because they view it as their money being taken. But I want to say this, when the client called me, and obviously I can't say too much, my first impression was, this is kind of on you. You should have performed internal audits. But one of the things they said, and I get it, right, is we hired an accountant who performed these reviews for us. And the accountant says that, well, he trusted the individual, so he never looked. That's in the news release. I'm not taking that from anything private. And he said, well, I trusted him. Okay. it's one thing when your brother and sister firefighters trust your treasurer, but your accountant is there to purposely distrust. So everyone's asking me, and I can't give you a comment. Everyone's asking me, are we going to sue the accountant? I can't comment on that, obviously, at the moment. But, I don't necessarily totally blame the fire department because they paid for a mechanism to review their books. Now, I don't personally at the moment, and now we see why, think that's sufficient, but you should be able to rely on an accountant who you hired for that purpose. And here the accountant's like, oh, I trusted him too. What the heck kind of statement is that? What do you mean you trusted him too? We hired you not to trust him. So that's what drives me nuts.
Well, the recommendations though were listed there, and some of the things that were violated here was access to the monthly statements from the bank accounts all went to the thief. And that's one of the key things that you want to make sure that the monthly statements and copies of receipts and everything go to someone other than someone with check writing or credit card signing authority. You want to make sure.
We're not in the 1970s. We have online banking. Everybody should have viewing access to online banking. Everybody on the board should have viewing access. They can see everything, and that alone will deter theft.
And there should be an audit committee, because sometimes you have a board of 6 or 7 or 8 or 9 people and we're all busy, and you say, oh, well, somebody else will look at it. There should be an audit committee. You don't have to have 100 people, but maybe an audit committee of 3 people that every month are going to reconcile and make sure, okay, there's a check to so-and-so. What was it for? Oh, yeah, that was engine 8 needed a new battery or whatever it was, and that they all line up with the proper expenses. Let's face it, we are easy pickings for people who would steal from us, particularly insiders. We distrust outsiders often, but when it's insiders, we tend to have a level of trust. And, we go back to President Reagan's statement, trust but verify.
Yeah. And by the way, in the fire service, it is always the person we trusted who steals from us. Yeah. Always. That's because we give him that level of trust that we don't verify. And look, I get it. It's very difficult today to find a treasurer. I'm going to do a little self-promoting. That's why my law firm has started a business called Fire Service Financials, because we're doing a ton of fire departments treasury work because it's very complicated, difficult stuff. And if your treasurer is doing things by hand, not using QuickBooks, not giving out bank reports and reconciliation statements, etc., you're missing the boat. You're going to be ripe for theft. So everybody, please stop trusting your treasurer. It's not personal, right? I always say, Pete, this isn't about you. We trust you. This is about putting processes in place for the next treasurer who we don't know who it is. So we got to start now.
And that's exactly how I had to deal with it too, because it can be insulting to the person who's been there and is honest. It can be very insulting to that person. And then they can say, fine, I quit, or, go find somebody else, whatever it may be. But you want to make sure that you characterize it, just like you said, that, look, we trust you. What happens when you leave? We want to make sure there's things in place so we're not trying to replace you and come up with all these things at the same time.
And I'll give the first tell as we wrap this one up. The first tell that you've got a good, honest treasurer, and I've experienced this probably 100 times, when you say, listen, we want to put these processes in place, the honest treasurer says, who cares? Go for it. I welcome it. The dishonest treasurer starts ranting and raving and bitching about, how dare you? I've been here 40 years and you don't trust me, right? Well, people who have no fear of being audited should have no fear of being audited. I mean, the crooks always will be fearful. So, okay.
All right.
Let's go to California.
Yeah.
Why not?
This is a crazy one. This is crazy.
I got to tell you, this whole week is some really complicated, interesting stuff, but this is unbelievable. I can make it simple, but I'm going to go a little bit into the facts, generically, but specifically here. So here we have a California firefighter who's suing, among others, a fire captain and another firefighter over an assault. And basically what happens is the firefighter is critical of these individuals of some things, and a couple individuals get very upset with him. So let's keep it that way. So they then start allegedly, this is all allegedly, right? This is not a court. I say this every time we do this. This is a lawsuit, allegations. We don't know what happened. I will jump ahead and say, but if it's true, people are going to start writing checks. Maybe not the department, but some people are going to write the checks. In any event, what happens is this complaint leads to a text message which says, you better not be in the same room as me, and F you, dude, you're such a, and he starts with all these racial, well, not racial, sex specific, I don't even like saying this stuff. So I'm not going to repeat it, but nonetheless, very threatening, right? Like, you better not be in the same room as me. There's no other way to interpret that as other than as a threat, right? It's like, if we see you, or next time I see you, and I have that lawsuit in any event. So there's then a written complaint now where the guy says, okay, listen, I've been threatened with right? I've been retaliated against, I'm being discriminated against, I've been harassed. And that statement would constitute all of those, I would agree. And then the big issue, right? The big incident happens on October 4th of 22, which is the department's annual bid night. Curt, can you explain bid night?
Yeah, many departments that have a bid system, there's a couple of different ways. In Providence, we had a bid system where when an opening comes up, the announcement comes out and you can bid on it. Many departments have a system where they bid once a year, and it can be a complete job bid. So I'm not sure the exact way that they do it out there. And by the way, the department is the Central Fire District of Santa Cruz County. Okay, so
their mascot, the Santa Cruz mascot, it is the Slugs. The Santa Cruz Slugs. Yeah, I don't know how I know that, but anyway, there you go. Okay, keep going.
Wow. Okay. So, and I know some departments, even here in Rhode Island, they have a total bid. So basically everybody in the department shows up for this one particular night, and every spot is open, and the senior captain bids first, and then the next captain, So all the officers bid, then the firefighters bid, and basically you fill up the spot. So it's a big deal. And it depends, there's things like vacation picks and a lot of other things. Who's going to be working certain holidays that are all factored in, besides your favorite station and your favorite officer and all that
But
stuff.
Here we get to the main legal issue.
But it's a big deal. Okay.
Not only a big deal, it is an actual function of the department at that portion of which clearly is a department operation.
Right.
However, and there's interesting wording in the complaint, they then go out to dinner, and the complaint says as a continuation of the bid night. Now that's
very
important
slick, very slick way to handle that, right?
Right? We're going to keep talking about it over dinner. Now, you know what's coming. Even though I haven't told you the rest of the facts yet, they're going to say, no. There's no dinner continuation to bid night. And that will be a factual issue, right? Was more bidding done at dinner? I assume not. I assume once bid night was over, it's over, and then we go out to dinner.
We complain about it, right?
Right. Yeah, exactly. Right. Complain about the guy next to us who got all the shifts I wanted. So in any event, at that point, a multiple series of threats, intimidation, and then leading up to an actual alleged assault of the plaintiff occurs. It even got to the point, and I'm going to highlight this. So there's a number of threats going on, etc. The guy the plaintiff who's being threatened gets up, leaves, walks out. They follow him outside, threaten him outside, right? Slap him, right? So they've already assaulted him, but he goes back inside and sits by a third party patron who has nothing to do with this. And yet allegedly, right, the assailants come back and sit in between the patron and the plaintiff firefighter, further threatening him. So this is going on a long time. The reason I think this is interesting is because I want to know who was a higher rank that was at bid night or was captain the highest rank, and who's watching this. You don't have any allegations about that, but this is a dinner. If everybody's there, if somebody's watching this happen, right, maybe they should have known, maybe not. That's going a little outside of these papers. In any event, the short is he then is assaulted at the end of this, and he sues. But look, he sues the individuals who did this to him, right? Of course, but they may or may not have a lot of money to pay. I don't know that his injuries seem, I mean, he was struck in the face with his fist, right? I don't know that his injuries are necessarily that significant. But nonetheless, you want somebody with deep pockets. You want the municipality. That is going to be a very tough road to hoe in this case. They're going for negligent hiring, negligent supervision, and those are going to be very tough, except for one fact. The assailant has allegedly done this before. He's got a history of it. Apparently, he choked another firefighter who was a captain during a work event, right? Now, that also was at it was a alleged work event at a restaurant. I don't know how often we're having work events at restaurants here, but nonetheless, that was a work event at a restaurant. He choked somebody. So there's a history of workplace violence or out of workplace violence, as the court may decide. The interesting legal question will be, okay, if you're aware somebody's a violent person, what does it matter where he is? He's a violent person. So now, does one incident make him violent? Who knows? Those are going to be the issues against the fire department trying to get the big money. But look, against this individual for assault, he should have it. The only one thing I didn't see,
if we can separate things, the potential liability of the captain and the other firefighter who did the assaulting, assuming that the facts are as alleged, and that's a big assumption. Right. You almost wonder, well, I don't even want to speculate, but there's always a lot of questions here. But assuming it is as it happened, the captain and the firefighter are going to be liable. Okay, period. The other question in my mind comes up, why weren't they disciplined? Apparently was no discipline over this. Why wasn't the captain who had assaulted people in the past, why wasn't he disciplined? Or was he disciplined? Did he go away for help and different things, and we're just not aware of it?
Or did the fire department say, we would discipline him, but this was a non-department event, which would be the smart thing for them to do?
Well, you have that, but you also have a supervisor. Okay, you have a supervisor, yes, off duty, but you have a supervisor assaulting a subordinate. Okay, and I think there's a lot of questions of fact in this. It'll be interesting to see how it plays out, but I think the complaint was pretty well pleaded. I'm not sure I could have gone in another direction with it. They covered the negligent hiring, negligent retention aspect of it. I think the department is going to answer some questions about, did they take measures to deal with this workplace violence issue? There's a number of departments across the country that are dealing with that very same issue, including in some cases firefighters who've brought firearms to work to finish the mission there. And the department is left like, well, we did what we could, or there's questions, did you really do everything that you could? So again, I think they're going to be struggling with that one. And you had mentioned before OSHA. And I did do a little bit of research in that OSHA requires us to have a workplace, or first you have to do an assessment to determine if workplace violence is a concern. But where it is a concern, you've got to have a policy on workplace violence.
And look, just to get a little bit off topic on workplace violence, if we've piqued any listeners' interest on that, workplace violence policies are there to protect you in your workplace, right? And so they apply to like the village clerk, the town clerk, where the workplace is defined. Here, however, what is our workplace? I argue that our workplace is not just the station, it's the community. So I argue, and when I form these threat assessment teams, as what is called in workplace violence, and we create a policy, what we look at on workplace violence is not just threats from our own people due to PTSD or other things, but we look at the community, arson, chemical suicide, road rage, domestic violence, terrorism, right? There's all these things. Shootings, assaults, stabbings, whatever, all these things have to be looked at for workplace violence against firefighters. This would have been one of them. And this is where this isn't PTSD as alleged. This is just somebody who's obnoxious and, whatever, allegedly, but
got an anger issue, sounds like, but
yeah, but I really, to me, I think his strongest part would have been, how is it that nobody else from the department is doing something? And now they lose anyway. And if it's a department function, he's your supervisor, you're done. Right. Just like sexual harassment, you're done. But anyway, it'll be very interesting.
If you have a workplace violence policy and it's directed even at your own workforce, and you have someone who has a history of assaulting people off the job, that does carry some responsibility when it comes to the workplace. You can't say, oh, well, he shot 10 people, but it was all off duty. So, we didn't feel the need, right. You know what I'm saying? We didn't feel the need to take any steps to protect our people in the firehouse.
Right. Right. It is. It's laughable. I agree with you. And so, but that's where you get into negligent hiring, negligent supervision, right? We didn't know about it at the time we hired him, but you knew about it once you maintained him, you supervised him, and you should have known. Whether one incident of choking somebody is so extreme as to impose that responsibility, I would say it is, but maybe they counseled him after and they thought it was all set. Anyway,
let me take us in one more direction here. But yeah. I've had a article that is sitting on my desk and I've been thinking about it. But the title of the article is "Our War with HR." Okay, and it has to do with the fact that HR wants everything kept confidential. If you deal with an employee behavior problem, it's got to be kept confidential. You send somebody for anger management, it's got to be kept confidential, which right. I understand on one side, but on the other side, it makes it look like management isn't dealing with this stuff. And for all we know, the department has been. They just have an HR department that keeps everything confidential, but they may very well have been dealing with this. And so that it makes it a little bit difficult to really understand just where the department's responsibility begins and ends in a case like this.
But that'll all get laid bare, right? They're going to have to put in, hey, we've dealt with it before, or we weren't aware of it, or whatever. Okay, well, let's go 1 or 3 steps worse, right? Because here we have off-duty conduct relating in an assault, or maybe off-duty. Now we have what's been determined to be off-duty conduct relating to a sexual assault. This is, you might as well just change the name of the department, right? This is not, in fact, we just dealt with another one. We deal with this stuff all the time. So here we have a federal court has dismissed a lawsuit. And look, courts don't like doing this because they recognize the serious nature, but it doesn't mean that there's an actionable question here, right? So we're in Kentucky, where federal court has dismissed a sexual assault claim against.
You and I covered this case. I don't know if you remember. We covered this case when it was first filed. And if you want, I'll run through the facts on it. Just because we've got a it's a career department, a City of Paris Fire Department in Kentucky, but they have a firefighter. But there's also a county fire department that's mostly volunteer fire companies, and we have this particular firefighter who is a volunteer. As well as a career firefighter. And he also is, from my understanding of it, he's a volunteer constable, police officer, I guess. So he occasionally, a couple times a month or whatever, he volunteers as a constable, rides around in a police car and does whatever constable.
And is in a uniform, importantly.
And, right, he's, so at any rate, he's 37 years old or whatever age he is, and he meets a young girl who is 17 in his role as a volunteer firefighter, and he apparently has sex with her on a couple of occasions. One of those actually happened at the City of Paris Training Academy. Yeah. The other one happened when he was in uniform and he was a constable. And each time he filmed the act, he apparently filmed the act, and he ended up being charged and convicted of creating child pornography because she was underage. So he ended up, he's got, I can't believe, 35 years in prison.
That's for that, about 35 years too short, as far as I'm concerned.
Well, absolutely. But I'm surprised. On one level, I'm surprised. I'm also surprised he wasn't charged with statutory rape or some of those other offenses. But at any rate,
That could have been for a person less than 17. A lot of statutory rape is 16 and under, so it could have been, right, an age issue. Who knows?
Yeah, but it's ironic then that if she's an adult for purposes of consenting to sex, she's a child for purposes of child pornography, a little bit. Yeah. But at any rate, he's convicted of child pornography. He's away in jail, and that is what it is. Now the victim files suit, and she's suing a number of different parties, and we're not going to get into all the other parties because she's suing the city, she's suing the police department, because apparently when one of the times when he was with her, he called city police officers that he knew and said, "I'm going to be at such and such a location with a girl. Don't come."
I don't think he said 17-year-old girl, but right.
Well, he didn't. Apparently, then there's a question: did he know? Did he not know? And right, all that. Okay, but bottom line is, she sues, and our focus in this case is she sues the fire department, she sues the chief of department, and also a battalion chief who apparently saw them together at some point. And it's unclear exactly what the battalion chief knew or didn't know. So this case was limited to the issue of, does the fire department, and this is the city fire department, which she was not a member of. She was a member of one of the volunteer companies that he was a member of. Now, you can almost say, well, maybe there's some liability out there. But the question is the city fire department liable? And is the chief of department and is the battalion chief responsible?
So to give some legal background to why, so what they put forth is the city failed to train and failed to supervise, right? Failure to train, failure to supervise. Some might say, well, why not just for the straight assault, right? For the straight sexual assault. And that's because of as you and I have talked about so many times, normally assaulting an individual, sexually assaulting an individual is not within the job description of a municipal employee. So the city would not be liable under a straight vicarious liability theory, meaning you assaulted the person, so we as your employer are automatically liable for that person's injuries. If sexually assaulting them was within their job description, which it's not, then that would be a different issue. So they've got to go through another circuitous route to get to a liability, which they haven't done. And I'll kind of explain why. It does have some good lessons for fire departments. So first, talking about failure to supervise, right? Control or train, you have to have a supervisor who actually encouraged the actual misconduct or the action complained of, right? And some way said, this is okay, this is encouraged, which can be done directly, which would never happen here, or it could be done through a blind eye. So, but at a minimum, the court says that the plaintiff, the female, has to show that the official, the person, raping her, and that the official's employer, at least somehow, even quietly, right, if not specifically authorized, approved, or knowingly acquiesced in the unconstitutional conduct. In other words, they'd have to kind of know this was happening, right? And they would have had to somehow say, oh, it's okay.
Yeah, deliberate indifference.
Yeah, deliberate indifference.
And I think my sense here is that the question, what they're alleging is that the fire department was aware that off-duty firefighters were taking women or whomever to the training academy during off hours and using it as a meetup place for sex. Right.
Here they didn't produce any evidence of that.
Right. And that's you'd have to show that the city was aware of it and they were deliberately indifferent to it. Right. And again, really important to understand here, they're not alleging negligence. They're alleging a civil rights violation. And that's important. I think a lot of times we kind of blur the distinction. Sometimes attorneys, when they're explaining this, or certainly newspapers and other people who are covering these cases, kind of blur the distinction and they make sort of generalizations about it. But this is a civil rights case. It's a constitutional case. Probably, as Brad said, it's outside the scope, number one. Probably there's tort immunity, number two. So the attorney that handled this case was going in the civil rights direction, which avoids both of those issues. And the court said, we're not seeing a civil rights violation based on these facts.
Yeah, and I couldn't figure out why, other than, well, this was in 20, when was this? This is recent. I was trying to think of statute of limitations. Maybe they couldn't meet negligence, so they went on the 6 year or so constitutional time.
It could be, and that's another good reason why attorneys sometimes will go in that direction. But the bottom line is, this was not a tort case. They could have gone in that direction, but there probably would have been more defenses. So
it would have been the same negligent hiring, negligent supervision. But here, and I want to talk about the failure to train aspect, because it's interesting, because what the court does is it compares them to police. An interesting way to do this, because I'm wondering where the next one is coming from with the police. But they say, listen, failure to train, you either have to be kind of aware of a systemic problem going on, or one so significant issue that it's an obvious that the failure to train would obviously result in someone's violation of their constitutional rights. For example, they talk about with the police officers, right? And how you restrain them, and the use of deadly force, I think the court focuses on, because that's such a significant issue that obviously a municipality should train people on that. And look, we do in the fire service, there are things we definitely do train on, but not, it's one of those things where you say, well, does the municipality really need to tell its firefighters not to take other young firefighters to one of our buildings and sexually assault them? Well, here's my 2 cents. Not as a matter of law, but as a matter of fact. Why? Because you and I keep covering these issues. Of course you do, right? You need to say, but the way we handle these usually is with junior programs, right? Somebody under 18, we say you cannot be alone in a room with them. I'm surprised with the volunteer department that they wouldn't have, or maybe there wasn't discussed in a decision, wouldn't have policies saying you cannot be alone with somebody who's less than whatever age. I mean, at least that's what I always do with junior program, 2 21-year-olds.
Too, but that's a tough sell. You'd be surprised. That's a tough sell. Guys don't want to hear it. The department's clients of mine, they don't want to hear it. When you say that, they don't want to hear it.
Wow. Well, then in that case, there could possibly be some liability. We recognize an issue, but we're not going to train you on it.
I tell them it's your ship to pilot. If you want to drive it into an iceberg, that's on you. But your lawyer is advising you to do it this way.
Fair. But I think that's important, because just as a failure to train, when you're going to lose a failure to train issue is when you're aware there's a problem. And that's why I'm coming up with this, because I would have gone a different way. I think the abuse of younger women in the fire service is not atypical, at least not to this blog, show. It keeps coming up, and we know that there's a pattern of this. Maybe not in that fire department, which is the issue, but in the fire service, it's not an unknown issue. So my point here to everybody is, please implement a policy, even though if you think it's stupid, saying that you are not going to allow any firefighter less than, 18 to be alone in a room with, one adult of the same or opposite sex, doesn't matter, who's less than 21, with
one exception. Usually we'll add an exception of family member.
Sure.
It's a father, that type of thing. But again, I really want to emphasize that what Brad just said is it's important for constitutional rights issues. It is not the law for negligence. Negligent training is going to be based on what would the reasonably prudent fire department have done under the circumstances.
Right.
Okay. That's a much lower standard than what we're talking about here with deliberate indifference and some of the other concerns that are discussed in the case. So it is important to keep that in mind. You can't say, oh, well, as long as we're not deliberately indifferent, we don't have any potential liability. No, you're still held to what would the reasonably prudent fire department have done.
Right. Okay, let's go down to the Fifth Circuit Court of Appeals. We are in Texas. The Fifth Circuit covers Texas, Louisiana, and maybe Mississippi. And we've covered this case before, if I recall.
We have.
So look, the facts, I'll summarize again because they're tedious, but basically this is an individual who claims he was fired for, as a lot of employees do, you're retaliating against me. I complained about something. I'm a whistleblower, right? We just saw this a little bit ago. And they then claimed, despite anything I've done, you retaliated against me. Well, here there was an issue where they believed he had a drug use issue, and
or alcohol. It might have been alcohol as well. They weren't sure.
Right. They weren't sure, either pills or alcohol. And in one instance, he goes to make a photocopy or wants some photocopied records. The secretary or clerk is there, and she becomes threatened by him, feels threatened. And by the way, I note that carries a lot of weight for the court, right? So this one individual, not a member of the fire department specifically, not a firefighter, says he seemed like he was slurring his words, seemed intoxicated. He barricaded me or wouldn't let me move past a certain point. Of course, he refutes that, right? But so that's an incident. And then there's another related incident where he goes to yell about this whole thing to this city council or to the council. Right. And he's told, you need to leave, you need to be quiet, you need to not, and he refuses. So I get to that. He says, look, I was suffering from sleep deprivation, which is not a drug issue, hypoglycemia, low blood sugar, right? Not a drug issue. And the city is smart. City investigates, right? As they should. They interview 9 different witnesses. That carries a ton of weight when you have an investigation and you interview 9+ witnesses. And wait, because I want people to see the factors that matter to a court, right? Because the court is determining these facts here and says, based on they interviewed 9 witnesses, they have an independent, the secretary, right? And it has nothing to do with the Disabilities Act, has nothing to do with alleged drug use or alcohol, even though it appears that he might have been drunk. He violated orders, he was insubordinate, he threatened and or assaulted an individual through action, and he's done, right? So we could go through the whole McDonnell Douglas test, which you and I have done. I don't know if we need to do that at this, 40th minute here, but the short is he sufficiently says, I've got a protected issue, meaning possible disability. And then the independent reason the city offers has nothing to do with it. Brilliant, smart, and presumably true. The court found it to be true that, listen, you were insubordinate, you threatened, it doesn't matter. And we warned you. They focus on, you were warned in January that there were other policy violations that could result in termination, and you kept violating that. So they get rid of them. But this is not uncommon, right? This is very common when you have any, especially PTSD seems where it comes to. And unfortunately, some people kind of are making PTSD less serious than it really is when they keep raising it, saying, well, I'm allowed, I shouldn't be disciplined because I have PTSD, and I shouldn't be disciplined for drug use because I have PTSD, and I shouldn't be disciplined for my violent behavior because I have PTSD. A disability is not an excuse under the law for inappropriate conduct. It doesn't, right? If you fire somebody for the disability, that's one thing, but the disability that results in impermissible behavior isn't excused. And by the way, I'm going to jump on because it doesn't really come up. Nobody ever mentions the Rehab Act. I never know why we don't see plaintiffs mention the Rehab Act, but it was only this morning when I got a call from a client said, we got somebody who's using drugs and we're afraid to get rid of them because, we don't want to discriminate. I said, no. The Rehab Act starts with, you must be in recovery. You're under rehab. You're not still using. And although it didn't come up here, didn't need to, if somebody's still using, and I know I seem like I'm off topic, but I'm not. If you seem like if you're using, the Rehab Act doesn't protect you. It's only when you're a recovering alcoholic drug addict. It comes up a lot in firefighting cases with methadone, right? Because you're using
the ADA says the same thing. The ADA says if you're using illegal drugs, that's not a defense. But if you have a history, you can't be discriminated against because of a history, but if you're still using, it's not. Brad, I want to go back to something you said, and only because it's come up. I can't tell you how many times this has come up for me, but you emphasize the importance of the fact that the city did an investigation and they interviewed 9 people. Okay. I can't tell you how many times I've had a chief tell me, I have to do an investigation. The guy did it right in front of me. He did it right in front of me. You still need to do an investigation.
Right. Because and not him, by the way, because he's a witness, but
and that escapes them as well. Like they want to suspend him on the spot. Okay. But yes, we got to do an investigation. It can't be done by someone who was a witness. So now you've got to have somebody else come in and do the investigation. That is what provides us with the objectivity.
Yes.
Okay. I can't be the victim of someone's misconduct, right? And be a witness.
Nope.
And be the investigator. And be the adjudicator, the person who makes the final decision. You can't do all of those things. Okay.
And yet that happens 9 out of 10 times.
If you get in a car accident with a judge, okay, that judge is not going to be able to preside over the trial that may be coming. Okay.
Right.
You know why? Well, because they're not objective about it. Okay. It's the same thing here.
Yeah. And I will tell you, I've raised that and lost. I have two cases now where we say you can't be the board who makes your determination about guilt, yet you're the investigator. You announce before the hearing, you announce your belief that he's guilty. And I keep quoting you to the courts, and I'm not winning, Curt. So you're really kind of killing me here.
Well, I'll get you the cases. I'll get you the cases.
They're the state's highest cases in New York State say you cannot publicly announce your belief as to the outcome of a case and then rule upon it. And yet I'm having a hard time.
Use the judge in the car accident hypo, because that way attorneys get it. They go, oh yeah, that'd be crazy if you get in an accident with a judge and the judge could hear the case. I mean, then it makes sense.
Yeah, but that's how it happens all the time. The chief is like, well, I believe this person, or I witnessed it, so I'm imposing the suspension, you're guilty. How is that constitutional? But happens all the time. And I will leave this section with this. All I can see is your dog chasing the rabbit, right? If you've ever attended Curt's discipline lecture and you talk about investigation, right? You have this picture of dog chasing the rabbit. We're presuming everyone's guilty and we just chase that guilt, right? We're going to prove that guilt. We're not going to look at other witnesses. We're not going to come up with any other thought. We're just going to prove he's guilty.
Got to catch the rabbit.
Got to catch the rabbit. Okay, let's go to Pennsylvania. And this is, look, I can make this really easy, but this is really interesting.
It is. And I feel so bad because I feel like the community that is around this fire department is being ripped apart.
Right.
You know, and my sympathies are to the folks that are in that department. And
I wish the fire chief would just resign, right? When the fire chief.
Yeah. Well, you don't know who is really, so I don't want to take sides in it, but
that's my point. And we'll get into the facts now. But my point is, if you're the fire chief and you're creating controversy, it doesn't matter whether you're right or wrong. You owe it to your community to step aside to relieve the controversy. That's just my belief. And I've been in that position, and I always take the municipality side and say, listen, fine, right? The community is the issue. Don't make yourself the center of a community's, difficulties. Just step aside.
I hear you there, but I also know sometimes fire chiefs have, they're put in a position where they have really unreasonable people in the organization. And what is it? Do we have a chief that's being unreasonable? Do we have a department with a few unreasonable people? Who knows? In the meantime, the organization is suffering. And I think that's to your point there that, if you're the boss and you're presiding over this, maybe you should just step away. I'll leave that to whoever's going to make that decision, but understand we don't know all the details. Sometimes,
let me give a couple of them. Let's go through a couple of them.
Go through
we've got a councilman of a city or a town. I'm not sure what he is. I assume a city councilman. He's been very outspoken on the fire chief, very, controversial statements. And this starts pre-COVID. This was going on a while. And the mayor says, okay, I'm going to investigate some allegations against the fire chief, et cetera. But COVID came and all that stopped. So then one of the fire companies, and the fire chief apparently is making threats against the members. And so one of the fire companies, which I guess the fire chief belonged to, voted to expel the fire chief. All right. And they then said, and we're going to pay for the prosecution of a suit or to defend against any suit against the fire chief. We're going to defend anything that's happening to you involving the fire chief. If you were suspended by the fire chief, we'll pay to sue if you need to defend something. So they write about $21,000 worth of checks, cheap attorney, as far as I'm concerned. Then it goes to hell in a handbasket from there because the now we've got the filing, I think by the chief, right, of criminal theft charges saying you can't file, you can't spend this money, you wrote out blank checks, you stole the money by deception. In any event, then we have an arrest of the people who are writing the checks, and it's all over, it's openly announced and publicized. So now then you've got another lawsuit, right? So it's going back and forth. In any event, ultimately what happens is, and I don't think the court resolved this. The court said, listen, we're going to take the money, put it into a fund, and a court was going to rule, but I don't think has ruled on whether that.
No, they did. They did. No, they did. They said the money was, and the city, the town did not contest it. Okay. So essentially the court, it was what's called an interpleader action. If I have money, let's say I'm holding money and that belongs to a client, and there's a dispute, maybe the client and their spouse, they don't agree on what should be done with the money, I can go to court, file an interpleader action with the court, give it to the court, so I'm not being accused of doing anything wrong, and then the court's got to figure out who's going to get the money. In this situation, the court said they were valid bills for those fire companies. The attorney was entitled to them, and the money was turned over to the attorney.
Yeah. And that's really where it ends. Interestingly enough, sometimes the attorney general.
No, this isn't the interpleader. That had already happened. Now we're in a situation where one of the people who was accused of committing the theft is now suing the fire chief and the borough and several other parties, alleging malicious prosecution, abuse of process, intentional infliction of severe emotional distress, and a bunch of different tort-related types of offenses.
Yeah, I mean, this just keeps growing and growing, where everybody has to keep upping the ante. And I will tell you, one of my advices for all my clients often is let things go. And people don't want to, but this is exactly the reason. Sometimes, you can only have a dispute when you're arguing, right? If somebody's just yelling into the wind about you, they're just yelling in the wind. And so many times they say, do you really want to keep escalating this? And this is a good example of that advice, why that advice should be taken. Sometimes it's better early on, let things lie. But that said, I was surprised that, and I don't know the laws in PA, but I do know they have a comptroller and attorney general's office that's very involved in public monies. I was almost waiting for them, the AG or comptroller, to come in and say, you improperly spent public monies. That didn't happen because it's a fire company, and PA, presumably a volunteer fire company and not-for-profit corporation. And they're subject to the comptroller and AG's audit, and they will protect public monies. They didn't come into this saying that the monies were spent improperly. I will note there's a case in New York State, I know because I was the attorney involved, good and bad, where the attorney general came in and said to a fire company, your president and treasurer need to pay the money back because you spent money impermissibly on attorney's fees, this exact case. And in that case, we lost a trial court. The trial court ordered the president and secretary to have to pay the money back that they paid to do work with an attorney. Opposite, by the way, another one of their stations, same deal, where they were infighting. It's almost the exact case. The appellate division finally comes and says, wait a minute, if the attorney told you you can spend money on, even though it's on himself, on attorney's fees, that is a good faith belief and there's no liability. That's where I thought this case was going to be going. But the AG and the comptroller never get involved in PA. And again, they are very involved. They have a whole bunch of documents on theft and fraud and permissible expenditures.
Brad, I don't know the answer to this question, but I wonder whether or not it's because that taxpayer funds are not being used. And many of these volunteer fire companies in Pennsylvania have their own income stream.
Yeah, they have restaurants.
They have restaurants. A lot of them have restaurants, and they have other activities. Some have bowling alleys, and so again, I don't know. I have never been to Latrobe. I don't know. I do know it's somewhat well known for a certain beverage that is brewed there. But at any rate, it could be that could be why, and that this is really coming from a separate revenue stream. I don't know.
Yeah. To me, the lesson from this is, you keep escalating things, and this is the craziness that it gets to, right? Up to the point of criminal charges and then a lawsuit because there were criminal charges. I mean, just this is crazy. This is a lot. I'm not blaming anyone there. I get it. Everyone wants to protect their rights. Sometimes it's just easier, cheaper, and better for your sanity to just let it go and let it be an old news story. Sometimes.
This type of nonsense is not good for the fire department. And,
it is not. It is not. What a great place to end.
The only people who enjoy this kind of stuff are people who are addicted to drama. And
well, I think you just described the fire department.
Well, no, because I mean, most of us just want to come to the station and do our job and go home and feel like we've made a contribution. And you have other people that they just can't leave these issues alone. They just can't.
Right. So if you don't feel like ending up on our show or in the newspaper or anything else, just bite your lip. It's hard to bite your lip. It hurts. Yeah. Right. But this is what happens when you don't.
That's going to do it for another edition of Fire Law Roundup. Please, if you haven't already done so, please subscribe and please help us. We're still a couple of 100 hours short of our goal for the next plateau with YouTube. But please click like and share, and we'll